I'm Leon Dackbert, and I'm a personal injury attorney, and today we're talking about artificial intelligence. That's right, AI. You get notice that you're under investigation. You go to the first thing you can think of, and that is an artificial intelligence thing like Claude or Gemini or ChatGPT. You ask it questions. What kind of defenses do I have in this allegations that's being brought against me? Can the prosecution find out about that later on? Well, a judge in the Southern District in New York answered that for us. And he issued a order this past Tuesday answering what is discoverable and does attorney-client privilege apply or does work product apply in the anticipation of indictment coming your way. So I pulled the order here. I want to go through it with you. There's a U.S. v. Bradley Heppner. And right away, I just want to give the background of what is going on here. So the Southern District of New York is the upper echelon for white-collar crime prosecution. He's basically taking that money from a publicly traded company and transferring that over to another company that only he owns and transferring that wealth away from the shareholders. And that's what the allegation is. Now, the FBI executed a search warrant, including his phone and including his computer. And one of the things that they found was there was some communications that Heppner had with AI Claude, which is operated by Anthropic, right? So these communications took place specifically in 2025 after Mr. Heppner had received a grand jury subpoena, and it was clear with discussions with government that Mr. Heppner was a target of an investigation. And this is very important. So without any suggestion from counsel that he do so, Heppner prepared reports that outline defense strategy, that outline what he might argue with respect to the facts of the law, and that we anticipated that the government might be charging. Counsel asserted, Heppner's attorney, was preparing these reports in anticipation of potential indictment. So the government's trying to get these communications that Mr. Heppner used after he kind of found out that this is happening, I'm getting investigated. I'm going to go to Claude and see if I can figure out what's going on and what my best defenses are. The prosecution wants those communications. The judge is ruling on this. What the judge found was two things. Because the AI documents were not prepared at the behest of counsel and did not disclose counsel's strategy, they do not merit protection of work products. That's number one. So work product usually comes into play whenever an attorney is preparing for a deposition, for example, or a hearing, and they just jot some notes down, like on the yellow piece of notepad, right? And those notes can never be entered as an exhibit or be in front of a jury, or opposing counsel can't get them because it's your work product. It's what you're thinking of in preparation for something. The AI documents do not merit protection under the work product doctrine because even assuming so, that they were prepared in anticipation of litigation, they were not nevertheless prepared by or at the behest of counsel, nor do they reflect defense counsel's strategy. So what that's saying there is that work product really just applies to the attorney at the attorney's direction. It wasn't about preparation with his attorney. It was just Mr. Heppner acting on his own, and that's why the work product does not apply, because it applies to attorneys' actions or directions or even their agents in preparation for litigation. The other part that was interesting is the attorney-client privilege. So attorney-client privilege is communication between a client and his or her attorney that are intended to be, and in fact were, kept confidential. And three, for the purpose of obtaining or providing legal advice. So what this is saying is anybody that comes in and speaks to me about their case and wants an update, that communication is held sacred. It will never get out in court. Same thing for like if my staff has a conversation with a client, same attorney-client privilege. Even though it's not me talking to them, it applies to my agents, so any of my staff as well, talking to the client. The judge said that AI documents lack at least two, if not all three elements of these attorney-client privilege. First, the AI documents are not communications between Heppner and his counsel. Claude is not an attorney, period. Now, there was a interesting policy-based context of why are we doing this? Why are we making it that an attorney has that special privilege with their client? And this is why. So the invocation of privilege, because all recognized privileges require, among other things, a trusting human relationship, such as an attorney-client context, a relationship with a licensed professional who owes a fiduciary duty and is subject to discipline. Basically, we need a human who has something to lose, right? If I give bad advice or something, it's my license on the line. If I lose that license, pretty devastating. I worked pretty hard to get this license. And that's why that threat of discipline helps keep sacred that attorney-client relationship, that I'm acting in the best interest of my client, right? Because obviously I don't want to lose my license at minimum. At maximum, I want to do the best I can for my clients, right? And having a good, honest relationship with a person who has a license and has a fiduciary duty and is subject to discipline is why the attorney-client privilege applies to attorneys and not artificial intelligence. AI companies, they don't have a license, they're not human, and they're not subject to discipline, right? They're not taking ownership of the legal advice that's given to a user if the user asks for it. If they get it wrong, there's not an attorney license up for grabs. If I get it wrong, there is. No such relationship exists or could exist between an AI user and a platform such as Claude, period. Another thing is, whenever you tell me something, clients anticipate for me not to tell anybody. And I'm not. And I can't, right? And if I do, it's a violation. But with Claude, I think it's like $20 a month. There are terms of services that the judge pointed to was that Anthropic collects data on both users' inputs and outputs and uses and trains Claude. And Anthropic reserves the right to disclose such data to a host of third parties, including governmental regulatory authorities. There's no expectation of privacy at all when you're using this tool. Heppner agreed to that by using the platform with the terms of services on the version that he got. And that's why there was not even an expectation of privacy, and not in this case when he used it to try to see if he could get some legal advice. Lessons learned, right? The lesson learned here is call a lawyer, get some good advice from a licensed professional, and especially for these criminal or personal injury matters or family law matters, you don't want that to get out to opposing counsel on items that you're trying to think of with Claude or Gemini or ChatGPT. The sooner you get to a lawyer, the more likely the attorney-client privilege is going to apply, and same for work product if the attorney asks you to prepare with AI. Second thing to keep in mind, use a tool that is enterprise, or use one that is not used to train their models. Use one with the terms of services that they will not disclose to third party, because you don't want to be using something that can be disclosed to third party if you're putting identifiable information in those prompts. Really interesting stuff. We're going to keep an eye out on this case, see how it turns out. But this specific ruling on the AI usage and the discovery of the prompts with Claude, really interesting to me to go through and see how the law develops.
My name is Leon Dackbert of Dackbert Law. If you've been hurt, give me a call.